In order to leave our virtual courtroom, you need to click the leave button in the lower right-hand corner of your Zoom screen, and then you'll be gone and we'll call our next case. The next case, I'm looking at this correctly, is Santoyo Truck Parts versus YB Trucking. See Mr. Cosden's name. I don't see him. There he is. Hello, Mr. Cosden. All right. Mr. Bilbrough, you're up.
Your Honors, good morning. May it please the court. My name is Bart Bilbrough, and I represent the petitioner in this case, Santoyo Truck Parts. I'd like to request 5 minutes of my time for rebuttal if I could. In this petition, we seek review of a January 28, 2021 order of the lower tribunal, which granted respondent YB Trucking leave to amend to add a claim for punitive damages in this case. Certiorari review is available to determine whether a trial court has complied with the procedural requirements of section 768.72 Florida statutes, as well as the rule requirements of 1.190F. In determining whether or not the plaintiff has made a reasonable and required showing under section 768.72, the standard of appellate review is similar to that in which a review is had of a complaint for whether it states a cause of action, or whether on the substantive issue, whether or not the record supports summary judgment, both of which are a de novo exercise. The instant action in this case is one of a commercial dispute. YB Trucking, the plaintiff in the trial court, has sued Santoyo, alleging that Santoyo did not provide them 2 used truck engines that they had purchased from them. The fact pattern generally is that the plaintiff's representative visited the defendant's shop, was looking for 2 used truck engines to put in their truck chassis, if you will, and saw the engines, agreed to purchase the engines, and ultimately delivered the truck bodies to have the engines installed. That was done, and the assertion in the case is that the defendant, my client, did not install the engines that the plaintiff thought that they were buying. There are multiple causes of action in the second amended complaint, which is the subject matter of this appeal. The amendment allowing for punitive damages, in addition to the other counts, of course, which are not bases for adding punitive damages, the ones for breach of contract and statutory violations. They also pled a count here for conversion, and it's the conversion count that they assert entitles them to the amendment to add punitive damages. Now, in this appeal, our position is that the defendant, of course, has a substantive right not to be subjected to punitive damages and the attendant discovery of financial worth until the requisite showing under the statute and the rule has been made. In this particular case, we submit to the court that there are a couple of errors here, one of which, of course, is the first step in this process. And I guess I should take a step back at this point and say, from a process perspective, the trial court has a couple of obligations when it's presented with a motion for an amendment for leave to amend. In the first instance, there's a procedural component to it. That is that there's got to be a complaint that sets forth, I think, 2 parts, if you will. You've got to have the ultimate, you've got to have the essential elements, if you will, of the punitive damage claim that you're bringing. Those have to exist. And then there's also got to be ultimate fact allegations that go to those essential elements that would supposedly support the claim for punitive damages.
Where is that in the rule?
I think that's the
Because
part.
the rule simply says the court must have a hearing. The 3 steps are that the plaintiff timely files the proposed amendment, timely files and serves and proffers the evidence upon the defendant before the hearing, and the trial court conducts a hearing. I don't think you dispute that those were followed. I don't see in this rule, and quite honestly, I think we would all three of us would agree, our review is very, very limited here because we must determine whether the court complied with the procedural requirements, not the sufficiency of the evidence. I know you quibble and you take great, you object to the sufficiency of the evidence, but that's something we cannot do. So my point is, you said this is like a motion for summary judgment, but we don't find whether there's a genuine issue of material fact. We're looking to see if there's a reasonable showing. And that's not defined in the law. It's a very low standard.
I would certainly agree with Your Honor that in terms of that appellate review of the sufficiency of the evidence is not allowed on a petition for writ of cert. So we're not in dispute about that issue. But I think before you get to the question of whether or not there's been a reasonable evidentiary showing, there is a precursor step that exists under the established case law here, which is that there's a pleading component to adding a claim for punitive damages. For example, in this particular case, what the plaintiff did was simply take its prior complaint for conversion, which has, besides the general allegations, the complaint has 4 or 5 essential elements of the conversion itself, and then just simply added to it the wherefore clause, a demand for punitive damages.
Did you file a companion motion to dismiss wherein the trial court would have the opportunity to review the pleadings to determine whether they state a claim of calls of action? I didn't see that in here. You just simply opposed the motion.
Well, that's correct. That's what the record reflects, Your Honor. But in terms of what the requirements are of the law, we would submit to the court that when evaluating the propriety of the amendment, it's at that stage where the court must have before it an amended pleading that sets forth the allegations that would support a claim for punitive damages. So it's not merely an evidentiary exercise under the case law that's developed in this area, but it's also an issue of pleading. And it's that pleading that is absent, if you will, in this particular case. For example, in order to properly bring a claim for punitive damages under this conversion claim, this is a corporate liability scenario, and under 76872, it lays out certain factors that are potentially ones that would allow for liability for punitive damages in the corporate context. In this particular complaint, there are no allegations, for example, that anybody acting on behalf of Santoyo acted with conduct that was actual knowledge or of wrongfulness or any kind of high probability for injury and damage. And despite that knowledge, intentionally pursued a course of conduct that.
Oh, but the record evidence shows that Mr. Santoyo is the only principal in Santoyo Truck Parts. Who else are they going to allege committed any negligence?
Well,
Mr. Santoyo is basically a sole proprietor who's incorporated.
Mr. Santoyo is alleged to be the owner of the company. I readily acknowledge that the pleading states that. But again, in order to comply with the case authority like Bistine, Lewis, all of these cases go to the proposition that you've got to allege the predicate for bringing the claim. That is that Mr. Santoyo, in this particular example, would have to have done the acts that he did with a knowledge of wrongdoing in some fashion, that there was an intent to harm the plaintiff in this case. And those kinds of essential element requirements, if you will, need to be pled in order to satisfy the pleading requirements of amending to add a claim for punitive damages. As a related proposition to that, this dispute, as it is presented in the pleading, and frankly, in the affidavit that was submitted as the proffer to support the punitive damage claim, was a breach of contract action. And there is nothing distinguishing the breach of contract, that is, that they didn't get the engine that they contracted to get, that turns this into a separate tort. And we have, of course, outlined in our papers the substantial body of case law that talks about the proposition that in order to have you can't get punitive damages on a breach of contract claim. that the breach has to constitute an independent tort before you can consider whether or not to grant an amendment to allow punitive damages on the independent tort.
I didn't see where you argued independent tort below, sir. You raised it on your petition, but I don't see where you argued before the judge on independent tort at all. Am I missing this?
Well, I think that we did make the argument in the trial court that this was a breach of contract action, and that there was no showing to make this different than the contract, or excuse me, the conversion claim was just simply a restatement of the breach of contract. I believe that was reflected in the transcript of trial counsel's presentation in opposition.
But did you ask the trial court to specifically rule that they failed to state a cause of action because they did not allege an independent retort?
I think that the substance of the argument was precisely that there was an insufficient showing of a predicate for bringing that claim. So that would be my answer to your Honor's point. So that really kind of addresses our issue of the distinction between the breach of contract and the conversion that we set forth in our papers. The whole notion behind punitive damages is that it's reserved for a particular type of behavior that goes beyond merely intentional torts. And I think much of the argument of the other side in opposition to our writ has been predicated on the proposition that conversion is an intentional tort and therefore punitive damages can follow. But the case law doesn't support that. Again, I would point the court out to this line that we discuss in our briefs, as well as Godradi versus Miami paneling.
I want to go back for a moment to what you argued earlier as far as the deficiencies in the amended complaint, or I guess it was the second amended complaint, that I think you said there were no allegations as to Mr. Santoya individually, his conduct, but in the general allegations, it seems to be filled with the context of what he represented and what he said he would do and what he actually did. So when you read that in connection with the depositions that were before the trial court, why is that not enough to state a punitive damage claim against the corporation?
Because at its core, accepting that testimony or those allegations as true, that those allegations are still not describing conduct that falls within one of the categories that makes liability exist under the punitive damage statute, that it has still got to be alleged that there was this intent to harm, and all that is described in the 14 paragraphs of the general allegations is simply that they purchased one kind of engine or one set of engines, and that they didn't get the second set of engines. They got a different set of engines in the installation. There is no allegation that there was any kind of no ultimate facts or even essential elements talking about that any of this conduct constituted the level of activity that's required in order to bring a claim for punitive damages. The last point that we raise in our petition is the fact that the trial court did not make findings concerning the particulars of how the evidence supports the punitive damage claim. I will tell the court that I only discovered this morning, Judge Northcutt, your recent concurrence that was in the last 30 days in the case, and I tried to send that opinion to Mr. Cosden this morning. I don't know if he got it or not, because I just discovered it this morning, and I apologize to everybody about that. But it seems to me that the law in this state is in a bit of a state of flux concerning the extent to which the trial court needs to make findings associated with this exercise.
You know how I'll vote.
I do know how you vote on that, Judge.
Well, let me point out, sir, that I'm well aware of it. And Judge Northcutt is an excellent judge too. But I think there may be a distinction that we all missed. East Bay deals with chapter 400. 400.0237 has a different standard of proof, which includes clear and convincing evidence. And in my East Bay opinion, I said what I said, but I don't think that we're clear on how that's to go about, but it requires sufficient admissible evidence to demonstrate the plaintiff can prove entitlement to punitive damage by clear and convincing evidence. It's a pretty high standard. And 76872 doesn't really put any type of burden other than a reasonable showing, and it says nothing about making findings, which I absolutely agree with. So
Yeah,
I don't want you to misconstrue that. I believe they're distinguishable.
Well, I think, again, and it's not really determinative of any kind of particular issue, but just overall, it seems to me that the case law, the status of the case law in this state is that some of the district courts of appeal, the 5th, the 4th and 3rd, for example, seem to require those findings. The 2nd has in, I think, East Bay, as you identify, I think there was another case, the name of which escapes me right now, forgive me, from the 2nd DCA. I think it was also, however, a Chapter 400 case, Judge Sleet, that did seem to apply that test. And then, of course, the 1st District.
Well, but the issue then would be in either case is whether, if we are not permitted to evaluate the weight of the evidence that's permitted, we're still in either case limited to assessing whether the lower court judge has followed the procedure. And it may well be certainly that findings might be helpful, but really what would be more helpful is a statement by the judge what standard of proof the judge is applying. And if we don't see anything, in the record or in an order one way or the other, then, we need to evaluate whether we can see that or see an error.
Yeah,
Yeah, if I could add, because East Bay is unique too, because the court even cited the wrong statute. So
right. I mean, but when we can see that, on the face of the order or in the record, then we can act. But I don't think, speaking personally, as someone who wrote the concurrence in Omega, I don't think a recitation of the evidence the judge relied on is helpful to what we're permitted to do in any event. So just saying.
Yeah, I understand. The other case I was referencing was the Life Care versus Croft decision of this court, which again, as I said, Judge Sleet was a Chapter 400 case. I would just say that and
let me point out, Mr. Bilbro, that I pontificated into your rebuttal time. So, if you want to save your 5, you probably ought to stop, but
I don't mind pontificating at all, Judge.
Have you ever pontificated, Mr. Bilbro?
I was going to say we could probably be identified as being done on all sides here. But the only other point I wanted to make to the court was that I don't think that the issue is merely one of assisting the court in undertaking an appellate review exercise. I think it's also part and parcel of that general public policy that underlies all of these things.
Well, and you know what, that certainly may be true, but it would be true basically in any case involving any kind of ruling. If the court has to make recitations, then it certainly focuses the lower court on the nature of its undertaking and so forth and so on. But the point being, though, doesn't seem to be required in the statute or the rule.
Yeah, I think that it has evolved, and as I saw your concurrence and read the opinions, I just started thinking a little bit about what other contexts in the law that we require the trial court to make these kinds of findings. And the thing that kind of came to my mind, frankly, was Kozel and its standards, which kind of has a punishment component to it, and there we require the trial court to either make findings or have a set forth in a transcript the specific, the consideration of those factors. And here, because particularly in a corporate context, when you have different ways, if you will, that one can bring a claim against a corporation or certain prerequisites that must exist in the record in order to do that, that in the same kind of punishment sense that Kozel operates, punitive damages operate in the same way. And I think that having those kinds of requirements are also appropriate in the punitive damage context. So unless the court has any additional questions, I'll reserve the remainder of my time. And I thank you very much.
Okay, you're down to a minute, and I'll throw in another one as compensation for my pontificating. So you'll have 2 for rebuttal when you come back.
Thank you, sir.
Okay, Mr. Costin, you're up.
Good morning, Your Honor. Petitioner did not address, either in the briefing or this morning, whether or not this court has jurisdiction to hear this petition. The court set out the rule very, very clearly back in 1995 in a case called Parkway Bank versus Fort Myers Armature Works. Parkway Bank has been followed and cited many times since, and by this court, by the other districts, and by the Florida Supreme Court. In that case, this court held that a certiorari petition must pass a 3-pronged test before an appellate court can grant relief from an erroneous interlocutory order. A petitioner must establish 1, a departure from the essential requirements of law, 2, resulting in material injury for the remainder of the trial, 3, that cannot be corrected on post-judgment appeal. Now, the Parkway Bank Court held that before this court has power to review the merits of a non-final order by appeal, a petitioner must establish that the interlocutory order creates material harm irreparable by post-judgment appeal before this court has power to determine whether the order departs from the essential requirements of law. If the jurisdictional prongs, being the 2nd and 3rd prongs, of the standard 3-part test are not fulfilled, then the petition should be dismissed rather than denied. Well, that's exactly what this court should do with this case, because there is no wrong here, no error that cannot be corrected on post-judgment appeal. Clearly, this court or any error.
Well, Mr. Costin, what if we were to determine, the judge made a mistake here by authorizing this punitive damages claim at this point, and then you start doing financial discovery, and that you wouldn't otherwise be entitled to. You couldn't fix that in an appeal from a final judgment, could you?
Well, yes, one probably could. The financial discovery could be made confidential. It could be reviewed by the trial court, and the parties and their attorneys could be ordered not to disclose any of that information. Of course, if a party
but the other party is not entitled to that information unless a claim for punitive damages is valid. Isn't that right?
That is correct.
So, isn't that why we review these kind of orders by cert quite often?
I don't think there is anything in the decisional law or any place else which would allow this court to address the issue without first having jurisdiction.
Now, Globe Newspapers gives us jurisdiction. Globe Newspapers gave us jurisdiction back in 1995. There's a substantive legal right not to be subject to punitive damages.
That is correct. Globe Newspapers did so hold.
Okay, so tell us why it's wrong.
Even if this court should have jurisdiction, the petitioner has not shown that he's entitled to the relief sought for several reasons. First off, the statute, the requirements of the statute and the rule have been met. there has certainly been reasonable evidence presented, a reasonable showing in the proffer that would provide a reasonable basis for discovery of punitive damages. The statute requires that to be held liable for punitive damages, a defendant must be personally guilty of intentional misconduct or gross negligence. Well, what is alleged here is that Santoyo substituted truck engines for the truck engines that were actually purchased and contracted to be installed in the trucks. Well, a trier of fact could certainly find that that's either intentional conduct, it's a pretty hard mistake to make, or gross negligence. I can't tell you what a trier of fact is going to do. We have not had a trier of fact look at the evidence yet, but that certainly could be a reasonable basis for a trier of fact to find gross negligence, or more likely intentional misconduct. It's pretty hard to mistake one serially numbered truck engine for another. The other problem here is that the arguments by petitioner address first the independent tort rule, which Judge Sleet has already addressed. I don't need to go on about that. Sufficiency of the claim, which I just addressed, but counsel in the petition cited a case called Bristline versus Rogers, where the district court held that to merit punitive damages, conduct must be egregious and sufficiently reprehensible to rise to the level of truly culpable behavior requiring punishment. Well, again, a trier of fact could certainly find that intentional or grossly negligent substitution of one truck engine for another, especially when the substituted engine didn't run, could be such reprehensible behavior. Requirement for a factual basis has already been addressed by Judge Northcutt. I don't think I need to address that again. And the other issue that counsel raises is a requirement for factual findings by the circuit court. Now, neither the statute nor the rule require that the circuit court make specific factual findings in the order. Of course, the circuit court, and I'm on page 94 of the record, the circuit court did not. The circuit court simply found that plaintiff has made a reasonable and sufficient showing of record evidence and evidence proffers to provide a reasonable evidentiary basis for recovery of punitive damages. Circuit court did not state what that record evidence and proffers repeated, nor is the circuit court required to. If this court should require that, then this court would be reading something into the rule or into the statute that neither the Supreme Court, in the case of the rule, nor the legislature, in the case of the statute, put there. And this court certainly should not be adding words to a statute or a rule.
We wouldn't be the first.
Sir?
We wouldn't be the first to do so, but.
Your Honor, it would not be the first time that this court has done so in my experience, but I would certainly urge the court not to do that. However, if the court did decide to do that, and I'm not suggesting the court should, What the court should then do is remand the case back to the circuit court for such specific findings, assuming that the circuit court can cite portions of the record to support such findings. That would be potential relief. But once again, I am not suggesting that the court should do that. So I will rely on the briefing for the remainder of the argument unless the court has any other questions.
Thank you, Mr. Cosden. Mr. Bilbrow, you're up. 2 minutes.
Thank you, Judge. Very briefly on the jurisdictional issue, it's pretty well settled at this point that certiorari is available where a defendant has not been afforded the statutorily guaranteed process that exists for the allowance of a claim for punitive damages. That purpose is a cat out of the bag type analysis that, as the court has indicated in some of its questions, is predicated on the notion that one is exposed to financial discovery that one ordinarily would not be exposed to absent the existence of the claim. So the jurisdiction for the review of this exercise certainly exists. The other point I want to make is simply that, again, that punitive damages are reserved for particular types of behavior that go beyond mere intentional torts. And there's a requirement, and I just read from the Varnick Ford's decision, that the trial court must first consider whether the proposed amended complaint actually sets forth a claim that the defendant's conduct will support punitive damages under the law, and that absent sufficient allegations, there would be neither a reason nor a framework for analyzing the proffered evidence as to the sufficiency for punitive damage purposes. That's the failure that we submitted occurred in this particular case, that the pleading does not set forth an appropriate basis, nor could it in what is essentially a commercial dispute about.
I will say, Mr. Bilbrow, in reading the transcript of the hearing, that specific argument was not made to the trial court. There was an allusion to the fact that, well, this is a breach of contract case, but it was never argued that the allegations of this complaint did not suffice for purposes of punitive damages. In fact, there is some reference to the Bisline case and the language there that merely pleading a facially sufficient claim is not sufficient. And there's no follow-up argument that here the pleading was not sufficient.
I will obviously defer to the court on its review of the record ultimately, but my reading of the record suggested to me that the thrust of that point was being made. That is that the allegations that were being made on the conversion count, which was the only count that was being pursued, was nothing more than the breach of contract. And in that context, a pleading like that does not satisfy the test of the statute and the rule. So unless the court has any additional questions, I thank you for your time, and we would ask the court to vacate the ruling on review. Thank you very much.
Okay, thank you very much.